Okay, welcome to all of you. Today we are going to have discussion on Indian Patent Act 1970 because one of the intellectual property after the copyright is patent. So what is patent? What kind of law govern the patents activities in India? That will be the subject matter today. So we will be discussing Indian Patent Act 1970, its features, then how the registration for the patent is required, whether it is compulsory or not. All this will be the subject matter of today's lecture. So I will be just sharing with you the screen and starting my discussion on Indian Patent Act 1970, which is one of the intellectual property as enshrined in the intellectual property laws. So this will be the subject matter today. So this we will discuss in detail. So as far as the patent is concerned, as I have already said that this is one of the intellectual property. A patent is a form of intellectual property that gives the owner the legal right. What kind of legal right? That is to exclude others from making, using or selling an invention. If you have made certain inventions, then it is your right to make it, it is your right to sell it, or it is your right to use it according to your wish. But this is for a limited period of years in exchange for publishing and enabling disclosure of the invention. So basically, patent is a intellectual property which provides a legal right to the inventor. What kind of legal right? That it will prevent others for using this invention, for producing goods from this invention or selling this inventions. And this right is provided only for a limited period of time, not for all the years for which you have to provide all these things. So therefore, patent is a limited kind of right which is available to the author, and only you can use it. If you have invented it, you can use it, nobody other can use it. So as far as the patent is concerned, whether it is patentable or not, whether it is required to be registered or not, we will apply three tests. So this you should note down, the three tests which are applied. First test is the invention must be novel, that means new. It should not be that it is already in existence or already somebody has done good amount of research on it or already it is in the knowledge of the people. So it must be novel, that means it must be new. And second is the invention must be non-obvious. Non-obvious means it is not known. The invention must be significant improvement to the previous one. Mere change in technology will not give the right of the patent to the inventor. So if you have already some kind of lamps or some kind of machinery and you make certain changes in it, you said that now it is an improvement, that is not patentable. It is patentable only if it is absolutely non-obvious. Non-obvious means it is not known to any purpose, and if you have made certain significant improvement in it, that improvement is not patentable. Thirdly, the invention must be useful in a bona fide manner. That means the invention must not be solely used in any illegal work or is useful to the world in a bona fide. Suppose you have produced something which is prejudicial to the sovereignty of the country, or if it is dangerous for the health of the people, or if it is going to be used for some illegal purposes, that thing is not patentable. So in order to be qualified for registering any invention under the Patent Act 1970, you must qualify the three things. Firstly, the patent must be novel. Secondly, it must not be in existence. It is non-obvious. Mere improvement in certain things is not patentable. Thirdly, it must be bona fide, must be useful in a bona fide manner, in a legal manner, which is not prejudicial to the interest of anybody or to the sovereignty of the country, or it is not objectionable from the culture point of view, from the ethical point of view. So it should not be objectionable. So all these things should be covered. So three tests we have to apply if you want to see whether it is so three tests are: number one, novelty. What is novelty? Novelty means invention is novel if prior to the date of filing the invention was not in existence, either orally, either in writing, or through any kind of use. So then invention is non-obvious. If it is not, it must not be predictable to the society. If known techniques are used to create ideas, give without predictable results, so these are not patentable. So it must be non-obvious, it must not be known. So already if some techniques are there and you just modify that technique and you say that this is novel, this is not novel. So therefore this process or invention which you have produced will not be patentable. Similarly, whatever invention you have made, that must be having industrial application. It must be used for industrial purpose. Grant of patent is not for illegal or immoral purposes. So all these three things, novelty, non-obviousness, and industrial applications, are the three preconditions to qualify a particular invention to be covered under the industrial patented under the act. Section 3 of the Indian Patent Act 1970 has prescribed certain things. Whatever things have been listed there, they are not patentable. So what is not patentable under the act, which is Indian Patent Act 1970, it has given the list of certain things. If anything is covered under that, that is not patentable. Number one, an invention that is frivolous or that claims anything obviously contrary to the well-established natural laws. There are certain natural laws. If anything which is proved that this is against the natural law, that is not patentable, number one. Number two, any invention, the primary or intended use of which would be contrary to the law or morality or injurious to the public health. We have a law in India, there are a number of criminal laws, civil laws. If anything which is produced, use of which is going to contrary to the law or contrary to the morality of that country or injurious to the public health, that will not be patentable. Thirdly, the mere discovery of a scientific principle or the formulation of abstract theory. If scientific principle which is already proved and you say that I have discovered it, this is not patentable. Similarly, the mere discovery of any new property or new use for known substance, the substance which is already known. If you have a milk, you say that I have produced some product from that and that product is patentable. No. So mere discovery of new property or new use for any substance, or the mere use of known process or machine or apparatus, unless such known process results in a new product or employs at least a new reactant, that is not patentable. So if you want to patent something, it must be first of all the discovery of the new substance, and if already known substance is used to produce new thing, then you must prove that it is new application and it results in the production of new product, or it has new reactant to that process. So therefore, if you are not able to prove that, then it is not patentable, then this act will not be patentable. Similarly, any substance obtained by mere admixture resulting only in the aggregation of the properties of the component, therefore, or a process for producing such substance. If you have already used certain things which you just make a mixture of it and it results in a new kind of thing, but already all these things, all substances are already in existence. You have just used a mixture and a recipe of that. Such kind of things are not patentable. Yes, if you have written a book on certain kind of recipes which are new, that a copyright act is there. According to that, you can get it registered under copyright. So you cannot register it under patent act. So the mere arrangement or rearrangement or duplication of the known devices, each functioning independently of one another in a known way, that is not patentable. Similarly, a method of agriculture or horticulture which are available, they are not patentable under the Patent Act. So for that purpose, we have separate act of plant varieties, etc. Or for regarding horticulture, we have separate act. So they will be covered under that. Similarly, inventions relating to atomic energy. This is a purview of the government of India. So no individual can do research without the permission on atomic energy. So if you develop certain substance in your lab that is illegal, you cannot do it. If you have developed it, then criminal proceedings may be initiated against you. So any invention relating to atomic energy, that is the purview of the government of India. So therefore, you cannot have any kind of invention on it. If you have, then it is not patentable under the Act. Similarly, any process for the medicinal, surgical, curative, prophylactic, or other treatment of human beings or animals, that is not patentable. For that purpose, other acts are there. Similarly, plants and animals in whole or any part thereof, other than microorganism, they are not patentable. Similarly, some mathematical business method or computer program per se or algorithm, they are covered under the Information Technology Act. So here it will not be patentable. For that purpose, you have to get registered under such acts. Similarly, literary, dramatic, musical or artistic works, cinematographic works, television productions, any other aesthetic creations, these are all to be covered under the Copyright Act. So therefore, these are not patentable. So similarly, mere scheme or rule of or method of performing mental act or playing game, they are not patentable. Presentation of information, that is not covered under Patent Act. Similarly, topography of the integrated circuit, for that purpose we have a separate act, so it is covered under that. So here it is not patentable. So we will be using that accordingly for that purpose. Similarly, an invention which is effect is traditional knowledge or based on the properties of the traditional knowledge, that means that is already in existence. So that is not covered under the Patent Act 1970 and not registrable under the Patent Act. So these were the certain things which were not covered under the Patent Act, which are not patentable. So you must keep in mind all other things which do not qualify, all these rules which we have just 13 items which we have discussed, they are patentable if they qualify the three conditions, three tests which we have applied. So as far as the patent is concerned, patent word is taken from the Latin word pater. That means to lay open. That means anything which is open for public inspection. If you have produced something, it is produced before the people and it is let down to the let the people know that this discovery you have made. If anybody has objection that no, this is not your discovery, they can make objection under the Indian Patent Act 1970. So therefore, in Patent Act 1970, there is allowance of pre-objection, and even if the patent is granted, post-objection is also allowed. So patent basically is a grant from the government. This is a license from the government. This is a recognition in the form of certificate by the government that it is for a limited period of time, and it is a privilege for the inventor for making use of this product patent and selling this patent and using this invention for producing the goods and services later on by using in the industrial application. So here patent is one kind of it. Patent is not basically a product. It is a registered invention which is in your name, which is granted by the government, which is for a limited period of time, and which grant the privilege to the inventor for making it, selling it, and using that invention. So this is covered under this. Now the question before us is why I go for getting a patent? Why it is required that if I have made certain inventions and I should get a patent? Because in the Copyright Act in 1957, it was not required or it was not compulsory to get a registered copyright. But under the Patent Act 1970, it is compulsory to get the payment if you want to enjoy the exclusive rights over the invention. Otherwise, other people will be using it and you will not be having any objection, and then you cannot make any noise on that. Secondly, if you want commercial returns on your invention, it is very much necessary that you get registered under the Patent Act. Your invention must be registered under the Patent Act, and you must get a grant from the grant means certificate from the government that this is registered under your name. Similarly, to protect your inventions and proceedings, it is very much necessary to get a payment, get a patent under the Patent Act 1970. Now, what is the need of patent as an individual? For me, to protect the creativity of the individual. Otherwise, nobody will make an invention. If you make an invention, somebody copies it, then it is not going to be benefited for you. So to protect their invention from being copied, it is not copied, therefore you need a protection. So to give a reward to the inventor, no reward will come to the inventor unless it is registered in his name and he use the commercial use of it. So this is the need that you must get the protection under the Patent Act. So for this purpose, Government of India has elaborately formulated Indian Patent Act 1970 with the provisions of which you get the protection and that your creativity is absolutely protected. So as far as Indian Patent Act is concerned, this is a long history of the Patent Act and Indian patent system. First act was enacted in 1856. The basic purpose was protection of invention. And then in 1911, Indian Patents and Design Act was formulated. But in 1970, a new, which is known as, presently known as Indian Patent Act 1970, Act 39 of the Government of India was promulgated, and it was operational from the 1972. And in 1975, India joins World Intellectual Property Organization, WIPO, which is an international body, and because of the provisions of the WIPO, you have to make certain changes. So after 1975, in 1999, India signed TRIPS, trade-related intellectual property rights, after joining WTO. Then in 1999, 2002, 2004, 2005, various amendments were made. Earlier, the patent was granted for 14 years, but for food and drug item, it was granted for 5 years. But now, product patents are, which are concerned, they are granted for 20 years patent period. Food and drug remains the same. So this is a small journey of Indian patent system, which started in 1856 and till now we have the Indian Patent Act 1970, which was operational from 1972. So this is a brief journey of the Patent Act in India. Now, as far as the Indian Patent Act 1970 is concerned, uh, it is an Indian legislation which controls the patent system. And in India, grant of patent is governed by the Patent Act 1970 and its promulgated rules, which is operative in the whole of India, which is known as 1972 rules. They are in operation, and according to that, we make provisions and register the patents, and various machinery is provided for protection of the invention which is done by the inventor. So as far as the Indian Patent Act 1970 is concerned, it has 23 chapters and 162 sections providing various provisions for the protection, explaining the meanings of the various items, and then providing the registration process, to whom you have to apply, what various definitions which are provided in that is covered in all these sections. So certain salient features of patent law in India is, but basically in India, we provide both product and process patent. It is not only that you produce certain products only, then it is provided protection under the Patent Act. If you have developed certain process which is novel, which is not earlier known, which is non-obvious, which has industrial applications, that can also be registered under the Patent Act. Similarly, the term of the patent is 20 years, and there is an provision for examination on request. Even if the patent is registered, after that, if somebody require that this should be examined, re-examined, because this is not a novel, then it is openable. Even pre-examination is there. So both pre-grant and post-grant opposition is there. If somebody oppose it in afterward, then it is considered also. Next, in this act provide fast-track mechanism for the disposal of appeals. You may appeal against the patent granted to somebody, but there is a fast-track mechanism which immediately dispose of the appeals by giving a justice to all the people. Then provision for protection of biodiversity and traditional knowledge is emphasized in this act. Similarly, publication of when you apply for patent, then your application is published after 18 months with facility of early publication. Also, if you request that it must be early publication, then it can be done. Similarly, substantially this act has so many good provisions in the act. What is the scope of patentability under the Patent Act? So already, first of all, it must be invention. Now, what is invention? Invention, as per section 2(1)(j) of the Patent Act 1970 says, inventions mean a new product or a process involving an inventive step and capable of industrial application. So first of all, it is novelty. Second, it is an inventive step. Something new has been developed. It is not it is non-obvious. It is not obvious. And thirdly, this invention must have the industrial application. If it has no industrial application, then this invention is not registrable under the Indian Patent Act 1970. This we must keep in mind. Patentable subject matter, it must qualify certain things, as I have already discussed with you, three tests which are required. Invention must relate to a process or product or both. It may be a product process, a product invention, it may be a process invention, it may be a combination of product or process invention. So both are registrable under the Patent Act. It must be new, as I already explained. It involves inventive steps, step-by-step procedure, something new is developed. It has industrial application and not fall under section 3 and 4, which I have already discussed. These are the things which are not patentable under the Patent Act 1970. If you qualify all these, then this is patentable subject matter under the Indian Patent Act 1970. What is new? Because I have used novel word. What is new? An invention is to be treated as new when it is not published. It is published in India or elsewhere. Invention must not be published in India. If it is already published, it is not new. If in prior to the public knowledge or prior public use in India, if it is already in public knowledge, already in prior public use, then it is not novel, it is not new. So it has not been claimed before in any specification in India, that will be treated as new. So this is the meaning of novelty or meaning of new things. Now, what kind of stages? Because as in the copyright, we discuss a process through which we have to go through to get copyright registered. Similarly, there is some procedure which is prescribed in the Indian Patent Act 1970 for registering a patent. So what are the stages from filing to grant of the patent? That means filing means initial application is filed till the grant of the application. What procedure is filed, that is the subject matter of this. So first of all, to get a patent, to obtain a patent, first of all, you have to file an application for the patent within one of the patent offices based on territorial jurisdiction of the place of office or residence of the applicant. For example, if you are in Punjab, your office may be in Chandigarh. If you are in Haryana, your office may be in Chandigarh. If you are in UP, your office may be in Lucknow. So on the website of Indian Intellectual Properties in India, nic.in, the list of the offices is given, and you have to see in which area your region falls, and accordingly you file an application, and you have to pay a required fee for that. And all information concerning the application form and details of fee are available on this website, which is www.ipindia.nic.in. As I shown to you on that day also, today we'll again see to it what it says. Let's go to the website of Yes, can you see the website of the Indian Patent Act?
सर पहले विजिबल थी, अब दोबारा फिर प्रेजेंटेशन इशू होने लगी।
Okay. Let's see to again. Is it visible? Is it
Yes,
visible
sir.
to all of you?
Yes, sir.
Okay.
Yes, sir.
You can see the website?
Yes sir.
Okay. So this is the website of IIPA, in which there is one section which is about the patents. If you click it, it will be telling you about us, history of Indian patent system. So whatever I have spoken to you regarding the history of Indian system, for example, we started from 1856, then journey to 1859, then 1872. So it's a detailed history. I have just discussed with you the brief. So it is a detailed history till the 2005, in which the latest amendment was made. So brief information about Indian payment system is also given on that. So here you can go and then what is the vision and mission of this Indian patent, that is intellectual property, and all these things are explained here. Similarly, the organization structure of the Office of Indian Patent, then the Office of Controller General of Patent, Design and Trademarks, that is given here. So where this office is located, uh, which is known as Rajiv Gandhi National Institute of Intellectual Property and Management. This one institute for that. Then patent offices, Kolkata office, Delhi office, Chennai office, Mumbai office, and then design offices, trademark registry. All these are components are explained here regarding the organization structure. Similarly, if you go to the administration part, then form and fees, what kind of form you have to fill to get the patent registered. This is the first schedule, fees, application for the grant of patent. This form one is given. If you open it, then it will give you the detail of the form. So all these forms and fees are given here. You can just access to it. Similarly, address of the patent offices, that is given here. So these are the various head offices of the intellectual property office. Who is in charge of that? All these information is given. So similarly, in publications, there are certain publications regarding it. There are service, there are, like in copyright act, we have this kind of frequently asked questions, which will be very helpful to all of you. So these are the frequently asked question, which is the latest guide for you. What is patent? What is the term of the patent? All these things are briefly explained here. You must download this and get it printed, so it may be useful for you to prepare notes regarding this, because this is an authentic information. No, from nowhere else you can find it. So this is a website of the patent, Indian Patent Act, under ipindia.nic.in. So you go on it and find out the various things. So what kind of mobile applications, public grievances, gallery, RTI information, all these are given on this. So this is what I want to explain to you, that this website includes so many things regarding to it. So here again I stop my screen and will start again from the point where we were earlier. Now the presentation is visible to all of you. Presentation is visible to all of you.
Yes, sir.
Yes
Yes.
sir.
Yes.
Okay. So so various guidelines for applicants are also available on this website. So you must go through the website of it. You will get a detailed information regarding the Indian Patent Act. Similarly, there is a procedure of formality check. An examiner checks the formal requirement. When you file an application, accordingly there is a appointment of an examiner who will check the formal requirement before accepting the application, and if he is satisfied, then immediately application is registered, and he will issue you application number and cash receipt. That is done on the same day. And in case you file your application through a registered post, cash receipt and application is sent through post within 2-3 days. So similarly, there is a publication. When you file an application, till 18 months, your application will be kept as secrets from date of filing. And in 19 months, the application is published in the official journal. That is a journal made available on the website weekly. Then applicant has an option. He may request that before 18 months that must be published. So in that case, application is published within 1 month of his request. Suppose you file an application, after immediately after 1 or 2 months you say, no, I cannot wait for 18 months. My discovery is so important that I want to have industrial application of it. So therefore, please do not wait for 18 months. You file an application for early publication, and they will publish your application in their journal, so that the people can know what kind of invention you have made. If they have certain objections, they can make objections to the patent office, and after that you are given an opportunity for that. So similarly, when you have filed an application, then there will be a request for examination. When application is examined on the request for examination can be made either by the applicant or the third party. Yani a period of 48 months from the date of filing is available for making request for examination. Within 48 months, you can file an application or objection to the application made by the others. Then there will be an examination. Application is sent to the examiner within 1 month from the date of request, which may be a scientist. So then examiner undertake examination whether the claimed invention is not prohibited for the grant of the patent, whether it is covered under section 3. If it is covered, then the application is rejected. If it is not covered, then if invention meets the criteria of patentability, that is the 3 tests, if it is qualified, then he will approve. He will issue the first examination report. That is a period of 1 to 3 months is available to the examiner to submit the report to the controller, and 1 month's time available to the controller to get the examination report. And the first examination report containing gist of the objection is issued within 6 months from the date of filing the return. So this is a process where the examination is done, then first examination report is submitted. Then if there are certain exceptions, then applicants will be asked to make explanations. 12 months time from the date of first examination report is available to applicant to meet the objections. If objections are met, grant of patent is approved by the controller within a period of 1 month. So whenever this process is over, he will issue immediately the grant of the patent. So a certificate of patent is issued within 7 days, and the grant of patent is published in the official journal of the Indian patent. So therefore, this process we follow. So these are the stages: filing to grant, the filing of application is there, then publication of application is there, then request for examination is there, then examination issue FER means first examination report. If they are satisfied, then grant of patent is there. Then if within 12 months, when decision of the controller is final, if you have objection, if it is rejected, the applicant may file an appeal and a revocation for amendment. So that goes to appellate board, like we go to the court. So similarly, this procedure is followed for grant of patent in Indian system. There is a renewal fees. It is not there that once the patent is granted, then you are free. The renewal fee is to be paid within 3 plus 6 months from the date of recording in the register. Every year, no fee is for first and second year. After that, on yearly basis, you have to pay the fee to keep the patent in force. And delay up to 6 months from the date of due date is permissible on the non-payment of fee for extension of time. Patent lapses if renewal fee is not paid within the prescribed time. So it means if you are granted payment, except in the first and second year, every year you have to pay the renewal fee. So various amendments have been made. For example, in 2005, product patent is there. New use of existing pharma product, certain provisions has been made. Patentability of the software has been ensured now. opposition has been provided, compulsory licensing is made, infringement has been defined, mailbox application. These are certain overview of the amendment. Similarly, pharmaceutical substances, fast track granting is introduced. In Indian filing, compulsory time period for request of examination is reduced, time period for examination and grant is reduced, revision of fees is made during all these things. So these are the brief outlines of Indian Patent Act 1970. In next lecture, we'll be talking about if you have a registered, got a patent and somebody make infringement, what kind of remedies are available to us. This will be the subject matter of next lecture. So it is advisable to all of you to go on the website of the patent and learn so many things, particularly the frequently asked questions which has been prescribed there. They must be studied by all of you and get a gist of it, because unless and until you read more the things, simply by listening the lecture will not be sufficient for you to get apprised of the various provisions of the act. This is just an overview which I have given to you in a very short frame and short manner, so that you can update your knowledge. So the facilities are with you, website is available. So on the website you can get a literature. There are various documents which are given to you. You can study instead of having notes from the any book. You can go practically on the website and see what kind of information is provided here. So these are the things. Now you on all of you your videos, on your videos.
सर मेरी क्वेरीज थी थोड़ी।
हाँ बोलो।
सर फर्स्ट ऑफ ऑल जो आपने बताया कि एक्सेप्शन है ट्रेडिशनल नॉलेज ऑफ इन्वेंशन, मतलब ट्रेडिशनल नॉलेज पे बेस नहीं होनी चाहिए, सर उसकी थोड़ी एग्जांपल दे देंगे जी?
ट्रेडिशनल नॉलेज फॉर एग्जांपल कोई जड़ी बूटी अवेलेबल है विच इज यूज्ड बाय हकीम्स और ਉਹਨੂੰ क्यूरेटिव पर्पसली यूज करते हैं एंड यू से नहीं आई हैव मेड सर्टेन चेंजेस इन इट सब्सटेंसेस ਇਹਦੇ ਵਿੱਚ ਮੈਂ ਬਣਾ ਲਏ, तो दिस becomes a novelty. This is not going to be invention. Similarly कोई ट्रेडिशनल सदियों तो चली आ रही कोई मेडिसिन है which is used by the people and you say now I have developed it, that this is not patentable. So even for example ਜਿਹੜੀ ਅਸੀਂ ਹਲਦੀ यूज करते हैं, somebody tries to get it patented outside the world, they said कि we have, but ਅਸੀਂ ਇੱਥੇ ਸਦੀਆਂ ਤੋਂ यूज कर रहे हैं, so इंडिया ਦੇ ਵਿੱਚ ਇਹ ਚੀਜ਼ patentable नहीं होगी।
सर नेक्स्ट क्वेरी है, आपने एक बताया था कि पब्लिक नॉलेज में हो तो पेटेंट नहीं हो सकती। सर इसकी मेरे पास एग्जांपल,
ਜਿਹੜੀ चीज ऑलरेडी पब्लिक नॉलेज है वो इन्वेंशन ਤਾਂ नहीं है। इन्वेंशन इज समथिंग नॉवल which is already in the public domain. Public know about it कि पंखे दे पर घूमदे है, left to right घूमदे है कि right to left घूमदे है। You said no, this is my invention. So which is already in the public knowledge. ਚਾਰ ਚੀਜ਼ਾਂ ਜੋੜ ਕੇ ਕੋਈ ਨਵੀਂ ਚੀਜ਼ ਬਣਾ ਲੈਂਦੇ ਹੋ ਤੁਸੀਂ, ਪਰ ਉਹ ਚਾਰ ਚੀਜ਼ਾਂ ਆਲਰੇਡੀ ਐਗਜ਼ਿਸਟੈਂਸ ਦੇ ਵਿੱਚ ਹੈ, ਤੁਸੀਂ ਨਵੀਂ ਚੀਜ਼ ਸਿਰਫ ਜਸਟ ਉਹਦੀ ਇੱਕ ਰੀਅਸੈਂਬਲਿੰਗ ਕੀਤੀ ਹੈ। that is not an invention. ਉਹ ਇਨਵੈਂਸ਼ਨ ਨਹੀਂ ਹੈ।
इससे रिलेटेड एक एग्जांपल है सर, अभी
आवाज थोड़ी मेरी बहुत घट है, थोड़ा ऊंची बोलिया कर।
सर पिछले मंथ में ना एक न्यूज आई थी कि पेट्रोल की कंपनीज है जो इंडियन पेट्रोलियम और भारत पेट्रोलियम, तो उन्होंने स्टार्टअप्स को ऑफर किया था कि आप पेट्रोल की डिलीवरी स्टार्ट करें फ्यूचर में। तो अगर जो कोई कंपनी, फॉर एग्जांपल मैं ही कोई ऐप डेवलप करता हूँ या वेबसाइट या कोई मोबाइल नंबर जहाँ से लोग डिलीवरी के लिए ऑर्डर कर सके, तो पब्लिक नॉलेज में पहले ही आ गई थी बात,
ये चीज पेटेंटेबल है ही नहीं। यू हैव नॉट हर्ड द थिंग्स, डेवलपमेंट ऑफ द ऐप, development using information technology apps, using computer IT processes, software, these are not patentable. ਇਹਦੇ ਲਈ अलग एक्ट है।
ओके,
ये पेटेंट एक्ट जाएगा ही नहीं।
ठीक है सर।
यस
सर, जैसे आपने कहा कि हाँ भी पेटेंट 20 इयर्स के लिए एक्टिव है, इन फोर्स है, तो 20 इयर्स के बाद पेटेंट को हम यूज कर पाएंगे या नहीं?
बिल्कुल यूज कर सकते हो। दैट बिकम्स ए पब्लिक प्रॉपर्टी। राइट होता खल्ले दा रहा ही नहीं।
मींस वो राइट हमारे पास नहीं रहेगा अगर हमने रजिस्टर करवा लिया।
की चीज
उसका राइट हमारे पास रहेगा या नहीं रहेगा सर उस पेटेंट को यूज करने का 20 इयर्स के बाद?
नहीं 20 ईयर्स तक तो ਤੁਹਾਡੇ ਕੋਲ ਹੈਗਾ, लेकिन 20 ईयर्स ਦੇ ਬਾਅਦ ਉਹ ਇੱਕ ਪਬਲਿਕ ਪ੍ਰਾਪਰਟੀ ਬਣ ਗਈ। ਐਨੀਬਡੀ ਕੈਨ ਯੂਜ਼ ਇਟ ਬਟ ਐਨੀਬਡੀ ਕੈਨ ਨਾਟ ਗੈਟ ਰਾਇਲਟੀ ਫਰਮ ਦੈਟ, ਔਰ ਉਹਦੇ ਤੋਂ ਕੋਈ ਉਹ ਅਰਨ ਨਹੀਂ ਕਰ ਸਕਦਾ। ਪੇਟੈਂਟ ਦਾ ਪੇਟੈਂਟ ਹੀ ਹੈ, ਕਿਉਂਕਿ ਲੇਕਿਨ ਜੇ 20 ਸਾਲ ਤੋਂ ਬਾਅਦ ਜਿਹੜਾ ਓਰੀਜਨਲ ਇਨਵੈਂਟਰ ਹੈ ਉਹਦਾ ਰਾਈਟ ਖਤਮ ਹੋ ਜਾਏਗਾ, ਉਹਨੂੰ ਰਜਿਸਟਰ ਨਹੀਂ ਕਰਾ ਸਕਦਾ, ਫਿਰ ਉਹਦੇ ਕੋਲੋਂ ਲਾਇਸੈਂਸ ਲੈਣ ਦੀ ਲੋੜ ਨਹੀਂ। ਐਨੀਬਡੀ ਕੈਨ ਯੂਜ਼ ਇਟ ਫॉर इंडस्ट्रियल एप्लीकेशन और एनी एडिशन। ਇਸ ਤੋਂ ਇਲਾਵਾ ਪੇਟੈਂਟ ਨੂੰ ਹਰ ਸਾਲ ਰਿਨਿਊ ਕਰਾਉਣਾ ਤੁਸੀਂ, ਐਕਸੈਪਟ ਫਸਟ ਔਰ ਸੈਕੰਡ ਈਅਰ, ਹਰ ਸਾਲ ਰਿਨਿਊ ਕਰਾਉਣਾ। ਜਿੱਦਾਂ ਤੁਸੀਂ ਰਿਨਿਊ ਨਾ ਕਰਾਇਆ ਤੁਹਾਡਾ ਪੇਟੈਂਟ ਖਤਮ ਹੋ ਗਿਆ, ਜਿਹੜੇ ਸਾਲ ਤੁਸੀਂ ਰਿਨਿਊ ਨਾ ਕਰਾਇਆ ਖਤਮ ਹੋ ਗਿਆ, ਬਿਕਾਜ਼ ਯੂ ਹੈਵ ਨਾਟ ਪੇਡ ਦਾ ਫੀਸ।
थैंक यू सर।
एक एक करके बोलो जी जी बोलो।
सर अगर जैसे इन्वेंटर अपना वर्क पब्लिश करवाना चाहता है 18 मंथ से पहले, तो सर वो फर्स्ट मंथ में भी करवा सकता है पब्लिश?
नहीं, फर्स्ट मंथ
मतलब कोई लिमिट?
there is a process। ਉਹ once it is filed you get an application, then ਉਹ ਤੁਸੀਂ ਭਾਵੇਂ ਫਸਟ ਮੰਥ ਚ ਦੇ ਦਿਓ, ਬਟ ਉਹਦੀ ਜਸਟੀਫਿਕੇਸ਼ਨ ਦੇਖੇਗਾ ਜਿਹੜਾ ਕੰਟਰੋਲਰ ਹੈ ਕਿ whether it is to be published or not। so if he is satisfied ਕਿ ਠੀਕ ਹੈ ਇਹਨੂੰ ਪਬਲਿਸ਼ ਕਰ ਦਿਓ, ਔਰ ਉਸ ਤੋਂ ਬਾਅਦ ਇਹਦੇ ਤੇ ਜਿਹੜੀ ਫਸਟ ਇਨਫੋਰਮੇਸ਼ਨ ਰਿਪੋਰਟ ਲੈਣੀ ਹੈ, ਐਗਜ਼ਾਮੀਨੇਸ਼ਨ ਰਿਪੋਰਟ ਲੈਣੀ ਹੈ, ਉਹ ਫਿਰ ਲੈ ਸਕਦਾ, ਕੋਈ ਦਿੱਕਤ ਨਹੀਂ।
थैंक यू।
Anybody else? So okay, kal fir apa next day, day after tomorrow we'll be having discussion on this infringement bare bhi gal karange, but naal di naal we will be talking about all these issues again। so you must read all the things from website। now I will be raising certain questions to you, similarly you may listen this lecture again and again, you may find certain points in it or you can supplement to that। so we will be having a joint interaction on day after tomorrow on all these concepts। so ਸਾਰਿਆਂ ਨੇ you must study the website in detail। ਜਿਹੜੀ ਤੁਹਾਨੂੰ ਵੈਬਸਾਈਟ ਦੱਸੀ ਹੈ ਉਸ ਵੈਬਸਾਈਟ ਨੂੰ ਚੰਗੀ ਤਰ੍ਹਾਂ ਦੇਖੋ, ਉਹਦੇ ਚ ਜਿਹੜੇ ਕੰਟੈਂਟ ਦਿੱਤੇ ਹੋਏ ਆ ਉਹਦੇ ਤੇ ਵਿਚਾਰ ਕਰੋ, ਸਟੱਡੀ ਕਰੋ, then we will come back again। okay, ਠੀਕ ਹੈ ਜੀ, thank you so much। thanks to all of you for joining। now you can off your video। thank you।